in your discussions?
Yes, ma'am.
Did he go over any possible lack of defenses with you in your discussions?
Yes, ma'am.
Did you inform him of all of the facts that you know to exist from this day with your attorney?
Yes, ma'am.
You've discussed with him all that you know to exist from your perspective.
Yes, ma'am.
And so you're satisfied with your counsel services.
Yes, ma'am.
All right, Mr. Pangburn, do you believe your client understands the nature and the purposes for today?
Yes, ma'am.
Do you believe he's entering the plea freely, voluntarily, and intelligently and knowingly?
Yes.
Do you believe he understands the elements of the crimes and the facts that support each of these elements?
I do.
Do you believe that he understands the maximum possible penalties that he faces today?
Yes, ma'am.
Do you believe he understands his constitutional rights and what he's waiving here today?
Yes.
And did you thoroughly go over with him the fact that it's the court's discretion in what I sentence here today?
I did.
And so you believe he's entering pleas freely, voluntarily, and knowingly?
Yes, I do.
All right.
Was there a deportation warning?
Yes, there was. Mr. Brown, do you have any questions before we proceed here today?
No, ma'am.
As to count one, intentionally point a firearm at a law enforcement officer, a firefighter, an emergency medical technician, an H felony, how do you wish to plead?
Guilty.
As to count six, battery or threat to a law enforcement officer, an H felony, how do you wish to plead?
Guilty.
As to count eight, failing to comply with an officer to take a person into custody, an I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those three crimes. The rest of the charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Renicky.
Thank you, Your Honor. As the court is aware, this is a somewhat complicated case. Originally, it started out in 23 CF 130, where we had 7 counts. And at the eve of trial, prior counsel made a...
Just like that, it's done. 3 felonies. Guilty. The judge formally finds that the plea is knowing, intelligent, and voluntary. That language matters. It protects the conviction from appeal later. The court is locking this in. The other charges? Dismissed, but read in for sentencing, which means they still count when it's time to decide punishment. This isn't a small win. This is strategic damage control.
Motion essentially saying that they wanted a more definite statement, in part because in some cases there were what I would call technically multiple crimes against the same victim. For example, striking an officer and then threatening an officer. And then the original case was dismissed without prejudice. The second case, which is the 24 CF 79, was brought. So that was how it went from 7 felonies to basically 14 felonies. The underlying facts really haven't changed. And I think they are fairly well set forth, but just to paraphrase, in the wee hours of the morning, the Grantsburg Fire Department returned to the fire station from an unrelated call involving either an ATV or a UTV rollover accident. And while they were basically coming back to the fire department and putting their equipment away and processing the way they were supposed to, somebody noticed that there was looked like a dark form in the street, and somebody went out to investigate, and lo and behold, it was a human that was still alive, but laying in the street in the dark, basically. And so they determined it was Mr. Brown and that he was still alive. And so Chief Barnett, as well as another EMT, by the name of Robert Jorgensen. The two men are two fire personnel, Chief Barnett and Robert Jorgensen went to aid Mr. Brown. And it turned out that he appeared to be drunk and either sleeping or passed out in the middle of the street near the fire station. And so upon waking him up, he gets up rather unsteadily and was somewhat hostile and combative, and they had words back and forth, but then they essentially told him to go home, and then they stood there and watched him as he either walked or, I suppose more accurately, more or less staggered into his house. They saw him get inside safely, and then they saw the lights inside the house turn off. And so as the two men turned around and went to leave to head back to the fire station, somebody looked back and noticed that the lights were coming back on. And not only did they come back on, but then Mr. Brown came out and re-exited the house. And this time, it appears that he has something in his hands, and lo and behold, it was in fact a pistol. It was a real pistol. It was a 9mm, and it was in fact loaded with a round in the chamber, or the action. And as he came out of the house, he was holding it. I guess it could be described as in a combat position, and he was kind of sweeping the area as if he was essentially looking for targets. And then in my discussions with Chief Barnett, I believe after the initial preliminary hearing and the initial file to get clarification, Chief Barnett, I remember telling me that essentially they made eye contact, and the defendant, Mr. Brown, actually pointed the gun at him and then took approximately 12 or so steps directly in his direction while aiming the gun directly at Chief Barnett. And so as they got closer, when they got close, Chief Barnett had the presence of mind to speak in an authoritative voice, knew that Mr. Brown was an ex-Marine, and basically said words to the effect, "Hey, Marine, put the gun down," or something to that effect. And then Mr. Brown actually responded and put the gun down. And so fortunately, nobody got shot, but as we heard earlier from Chief Barnett as the victim, it obviously had a major effect on him. Chief Barnett ultimately then picked up the gun, saw that it was a real gun, saw that it was loaded, and he was able to eject a shell to clear the gun so that it was not loaded. And after clearing the shell,
This is the moment everything could have ended. A loaded 9mm, round in the chamber, combat stance, 12 steps forward. That's not confusion, that's escalation. And when Chief Barnett says, "Hey Marine, put the gun down," that's instinct meeting instinct. Military recognition cutting through intoxication. Ask yourself this: if Barnett had hesitated 1 second longer, would we be talking about sentencing today or a funeral?
the defendant takes a look at him and apparently gets angry for what he thinks is wasting ammunition, and then starts to verbally threaten Chief Barnett's life, saying that he's going to kill him because he's wasting ammunition. So at that point in time, or shortly before that, or when they see the pistol and Mr. Brown coming with the pistol in his hands, EMT Robert Jorgensen then turns around and runs back to the fire station. So Chief Barnett was there alone at the time that the gun was later put down and then recovered. Chief Barnett took custody of the gun and the bullet and the clip, and then kept it safe, and then turned it over to, I believe it was Brady Mangan, the Siren police officer, who was a mutual aid help at one of the multiple officers that were there. Eventually, James Brown goes back into the house, and again, it could have more or less ended there, or at least the danger part ended there. But around this time, the other law enforcement officers start to arrive, either the SWAT team or the multiple officers from multiple jurisdictions. They try to determine what's going on. They take positions in the area, trying to keep everybody safe. And at some point in time, while they're still trying to figure out what to do next, Mr. Brown exits his house a second time. And this time he has what appears to be a long rifle in his hand, and he's more or less doing the same thing, where he's sort of sweeping it around as if he's looking for targets. Deputy Noah Barker is, I think if I've got my facts right, somewhere between 80, 90, or 100 I'm not sure if it's feet or yards, but he's some distance away, basically at around the corner of a house, somewhat behind or near a air conditioning unit. Other officers are in various other areas kind of surrounding or semi-surrounding the area. And various law enforcement officers are instructing the defendant to put the rifle down, and he refuses to do that. And then at some point in time, he's like he walks, so he's essentially near a neighbor's house, and ultimately siren police officer Brady Mangan is there. Deputy Sheriff Chad Brugman is in the immediate area. They're all telling him to put the rifle down, and he's refusing to put the rifle down.
And just when you think the danger's over, he comes out again, this time with a rifle. Now, we're not talking about a chaotic drunk moment. We're talking about a second decision, a second weapon, a second opportunity for tragedy. Officers are positioned, distance measured, fingers near triggers. This is how officer-involved shootings happen. And remember, a deputy actually fired 3 rounds. By pure luck, nobody was hit. Luck, not control.
And at some point in time, a lady who's, I think, a social worker is in the area. She comes by, she knows Mr. Brown, and she sort of orders him to put the gun down, and he more or less gives the gun up to the lady. Unfortunately, at this point, that's Patricia Wenthy. At some point in time, the officers both threatened to and ultimately try to use a taser on Mr. Brown to get him to drop the gun. One of the tasers, I think, either struck a jacket or some clothing. The second taser unfortunately struck Miss Patricia Wenthy herself. But in any event, Mr. Brown is kind of going through alternate waves of either being cooperative or sometimes jovial, sometimes laughing, and sometimes being hostile. And when he's hostile, he's threatening to tear their faces off and to kill them and things of that nature. And so at some point in time, he actually starts wrestling around with Sergeant Brugman, who's trying to take him into custody and to handcuff him. And Brugman actually is asking the other officers to control his arms and legs because to stop him from kicking him. So this wasn't simply a threat, but he was actually kicking and striking Chad Brugman before they can get him into control. And he's refusing to listen to siren officer Brady Mangan as far as letting himself get arrested. By then, he ultimately does get arrested and handcuffed. He's taken to the Burnett County Medical Center for evaluation. And again, he starts going through this waves of going from being jovial and happy or cooperative and being very uncooperative and being threatening. He makes some mention that he's Wolfie or Mr. Wolf or a werewolf or something like that, and he's going to bite him. And he attempts to bite Chief Siren Officer Trevor Tex as well as Deputy Jared Woody. And so he starts to threaten to kill both Chief Tex and Deputy Woody. He sort of wrestles with them and attempts to bite both of them until they more or less have to wrestle with him and get him subdued into custody yet again. And then ultimately he's taken to the jail, and then he ends up going to jail for 96 days. It turns out he has no prior record. He did have a Burnett County case back in called 18 CM 269, in which he was charged with a misdemeanor battery, misdemeanor disorderly conduct, and obstructing an officer. At that point in time, Assistant Daniel Stephan worked out a plea agreement with him for a DJOC, which he apparently successfully completed. And then depending on when and where you try to look up on CCAP, it actually doesn't even appear on CCAP anymore, but he did successfully do that DJOC. I can find no criminal convictions under his name or birth date, either in Wisconsin or Minnesota, so he has no prior record. Clearly, this is a dangerous and disturbing situation, and I can feel for the law enforcement and the victims, and I understand their frustration. Originally, we were going to ask for a PSI, but we both decided to waive the PSI. I know the last time the court was concerned with what his prior record was, and that's why we looked for it and can't find any other than the prior 18 CM 269 DJOC. Part of the thinking that went on in this case is this was a multi-jurisdictional investigation. To be perfectly candid, all of the police reports were not as clear as they could be because essentially it was turned over because during this melee or this chaos or this situation, Deputy Noah Barca did fire his service rifle at the defendant, I believe 3 times. We don't know exactly where the bullets went, but fortunately they didn't strike anybody from the defendant to anybody else. Because there was an officer involved shooting, it was investigated by Polk County. When we got basically the Burnett County deputies and the local police officers were essentially told not to write up reports and it was going to be investigated out of the county. So essentially they didn't. And then when the out of county officers investigated, they basically investigated as to whether or not the officer involved shooting was justified. And they never investigated as to what, if any, crimes were committed or what crimes would be referred. So I had to piece together literally hundreds of pages of investigation, hundreds of hours of either investigation, listening to tapes, videotapes, in terms of getting even the charge regarding Chad Brugman, which seemed to be relatively clear. He never affirmatively reported and nobody ever affirmatively wrote down that the defendants kicked Chad Brugman. I had to glean that from the fact that Chad Brugman told people control his legs and get him to stop kicking me. So I had, intuit that he was therefore kicking Chad Brugman. And so the case, as the court is aware, was on the eve of going to trial. I think it was in February. We had these motions for clarification or for more definite statements. Essentially, the prior attorney was asking me to essentially bring more charges to make everything clear so that the jury wouldn't be confused, which is what I did. But we believe, in spite of the fact that there's 14 counts, the original 7 were actually appropriate, and we're essentially getting a felony conviction for each of the major types of criminal activity. Now, as the court is aware, it's kind of a pig in the poke or a little bit less consistent than we would like as far as PSIs and their recommendations. But in this case, other than Noah Barker shooting, unfortunately not hitting anybody, but nobody else physically got what I would call seriously hurt. There's psychological trauma. Maybe there's some workers' comp restitution going on for people that missed work. There was a couple of wrestling matches. But all in all, we believe that this does comport with the public interest. Clearly, the defendant has mental health issues by having a felony, as the court is aware, and as the defendant was informed in the colloquy, he no longer has the legal right to legally possess a firearm. Sobriety and AODA issues are probably paramount. He says he's got lack of sleep and he's got large amount of alcohol consumption. And so this is the type of thing, and he has spent a relatively immediate punishment of 96 days of jail. Now, 96 days of jail isn't prison, but on the other hand, it was without work release, and it was the original 96 days. He posted a large quantity of cash. Since he's been out, we're unaware of any bail violations. And so I believe that a withheld sentence and 3 years of probation on all 3 counts is actually appropriate and not too far out of the realm of what fits the facts of this case. There's the 96 days of jail on a withheld sentence. If he does violate his probation, he could be revoked and come back to court for further sentencing at a later date and possibly get a maximum consecutive executed sentence at that time. But for now, I don't see any real reason why he can't be essentially treated within the community and supervised within the community. So we would ask the court to follow the joint recommendation.
Here's where it gets interesting. The state, after describing one of the most dangerous standoffs imaginable, is recommending a withheld sentence and 3 years of probation. Why? No prior record. Mental health issues. 96 days already served. No bond violations. This isn't about minimizing the danger. It's about risk assessment. The prosecution believes supervision and treatment protect the public more than prison does. But here's the debate. Does pointing a loaded gun at first responders justify community supervision or incarceration? You decide.
Yeah, well, I'm not sure what the restitution is, but I imagine our victim witness agent has filed requests for restitution if there is any. Otherwise, the usual fines, fees and DNA sample and court costs for all 3 counts.
Thank you. I don't have any request for restitution. Is there any? No. All right, no restitution is being requested. Mr. Pangburn, I am now going to turn to you for argument and sentencing recommendation, please.
I don't mean to interrupt, but I've got in the notes here $1,814.11 for
Let me stop.
Workers' comp medical to Jared Woody.
With Jared Woody?
Right.
With any of the victims that I have present here today, is anyone asking for restitution? I can set a restitution hearing. I don't need figures here today. If there's anyone, please raise your hand. I see no hands. I have a request apparently in notes from DA Renicky that's requesting restitution from Officer now Chief Woody. I'll follow up on it. All right, so I'm going to give 30 days perhaps for restitution hearing request. All right, Mr. Pangburn.
Thank you. I'd like to speak primarily about Mr. Brown's background. I think it helps to understand how we got here today. If we can understand something about him and his life, it's an unusual set of circumstances from what he's described to me. He was not originally born in the United States. He was born in Russia. He lived there for 6 years. His mother apparently passed away. She had some mental illness issues as he does, and she passed away when he was approximately 2 years old. He said he was a toddler. His biological father was quite abusive. He ended up living with his biological father until the age of 6. Until a family from Tennessee that was looking to adopt and apparently decided they wanted to adopt a Russian child, ended up adopting James and bringing him to the U.S., where he eventually became a United States citizen. As a teen, he was diagnosed with PTSD as a result of the abuse that he had suffered at the hands of his father when he was a young child. And he was diagnosed with ADHD as well. When he graduated from high school, his adoptive parents wanted him to go to college. It wasn't really what he felt was the thing for him, but he went. And it turned out it wasn't for him. And he lasted there about 1 year before he left. Spent some time just kind of moving from job to job. And then when he was 25 years old, he decided he would join the United States Marine Corps. That is a bit unusual for someone who has ADHD. I know from experience, because my son couldn't join the military because he had ADHD. And when I mentioned that to Mr. Brown, he said, well, the recruiter said to keep it to myself. And if I wasn't on any medication that would show up on a drug test, that the Marine Corps wouldn't know. So he kept it to himself and he stopped taking his medication and he got into the Marine Corps, which obviously was probably not the ideal situation, but it's what happened. So he served from 2010 to 2015. My understanding is he received an honorable discharge. He was primarily doing computer IT type of work. They provided him with the training that he needed for that, the education, and then he did that work for the 5 years that he was in the Marine Corps. He said prior to that, he's 25 when he went in. Prior to that, he didn't have an alcohol problem. But while he was in the Marine Corps, that is when he really started drinking. I don't know if that was a cultural issue. I didn't ask him that, or if that was in response to stresses of being in the Marine Corps. I don't know. But that's when he started developing a drinking problem, was when he was in the Marine Corps. He got out in 2015, and then he obviously had a span of about 8 years from 2015 until this incident in 2023. Where, as he describes it, he kind of went from place to place. There were various times where he was homeless, as a lot of veterans unfortunately are. He continued to suffer from his mental illnesses. He continued to consume alcohol. He worked jobs when he had them. And eventually he ended up here in Wisconsin because his father, his adoptive father, is from here, grew up in the house that he lives in now. That was his grandmother's house. And he asked James to move into the house when she had to go to a nursing home to take care of the house. And now James owns the house and he still lives there. So that's how he ended up here in Wisconsin. But even then, he was still primarily alone. He tells me that during that pretty much 8-year period until this incident, he tried to deal with things on his own. He kept himself very isolated. He consumed a lot of alcohol, sometimes worked, sometimes did. I mean, it's unfortunately, I think, kind of not so unusual story, right? As far as what happens to people who have mental illnesses, who have substance abuse issues, who have trauma. Some are veterans, some are not. He happens to be a veteran. That's certainly not exclusive to people who have these problems, but it's not uncommon for people who have these problems to be veterans. After this incident, he tells me he stopped drinking. I don't know. There's been no bond violations. He's been on bond for about 16 months. He's been out of custody for about 13 months of that 16 months, and I'm not aware of any bond violations. The thing that seems to be most positive for him now is he tells me in December, he told me the day, on December 10th, 2023, he met his girlfriend who's here with him today, and now they live together. And he said that's been a very positive experience that has helped him turn his life around. And she tells me too that she has not seen any drinking from him since she met him on December 10th, and he seems much happier and healthier. And as I indicated, he was spending a lot of time intoxicated and alone. And he's not intoxicated anymore. He's not alone anymore. And that seems to have been helping him quite a bit since he got into this relationship, which makes sense because being alone when you have these issues and being impaired a lot and using substances is not going to lead anywhere but a bad place. And he describes that he would go in a downward spiral and things would just get worse. And like, as he said, he wouldn't sleep for days at a time.
Now the defense shifts the lens. Abuse in childhood, adopted from Russia, PTSD, ADHD, Marine Corps service, alcohol spiral, isolation. This is the part where courtrooms become complicated, because two things can be true at the same time. He was traumatized, and he terrified people. The law doesn't ignore trauma, but it also doesn't excuse endangerment. The real question now isn't what happened, it's what kind of future the court believes he deserves.
There's holes in his memory because he was impaired, but he seems to be doing substantially better now. He is working. He's been at not terribly long, but since July of 2024. I don't know this company. He says it's called Equus Magnificus. They make horse treats, apparently. He seems to really like it. We spent quite a bit of time today talking about his job. He works third shift there, 40 hours a week. So he seems to, he's working, he's sober, he's in a relationship. And as I indicated, he seems to be doing much better. He has no prior record, as was indicated. Apparently there was an issue. I didn't see it on CCAP, so I wasn't even aware that he had the prior charges.
For the record, I am aware of 18 CM 269. That case was in front of me. It was a DJOC. I'm well aware of that case. I'm well aware of the DJOC. I'm well aware of it being dismissed. I have access to that DJOC.
Right. I understand. So no prior criminal convictions. He obviously spent 96 days in jail, which is a significant punishment for anybody, especially when, as indicated by the state, you don't get to leave and go to work or do anything else. It's just time that you're in custody. Clearly, there is a need for rehabilitation that we hope can be accomplished on probation. There, as indicated, he has a medical issue, which is ADHD, which can hopefully be treated with medication, and he has the mental health issue, the PTSD from his childhood trauma. He's doing his best to deal with those on his own, but I don't know that he's adverse to accepting help through probation if additional help that seems to be necessary. And he's got the substance abuse problem, and certainly anybody who has a substance abuse problem can benefit from AODA classes. So I'm sure the DOC would do both of those things if he were to be placed on probation, which will assist him with rehabilitation. I think being on probation provides a level of protection to the community because there is oversight. There's obviously punishment because he served time in jail. And there is a significant deterrent effect, I think, by being on probation, because he knows, as the court told him a number of times, that he's facing a significant number of potential felony longer felony sentences if he's revoked. He's got 2 Class H felonies, 1 Class I felony. So he is facing a significant amount of time, which I hope would have a deterrent effect. He does not own any other firearms. The one firearm that was taken on the night of the incident is the only firearm that he owned. He has not obtained any since then, and now he understands that he can't own a firearm. So I think that provides some protection to the community as well. I understand the sentiment of the individuals who were here speaking today, but I agree with the state that I think we fashioned